Hello, everybody. How you doing? We're here today to talk a little bit about Kathleen Zellner's reply to the state regarding the destruction of the bones, quarry bones, basically, or the fact that they were given back to the haul box and buried. So those are not exactly easily accessible for testing now, and by doing so, the state violated a statute and those sort of things. So we're going to hear Zellner's reply about that today. Want to say a couple things first, though. Been getting a lot of complaints lately, folks. Some people that really like to come here and get information and get education on the case and stuff, but they complain about the live chat being kind of chaotic and overwhelming for them and that sort of thing. So in the interest, of just keeping it, on point, the moderators tonight are going to be, very strongly enforcing the rules, essentially. You guys know I hate to make rules. I hate it. I don't like it. But look, we got to try to create some order in the live chat because it's becoming a slight problem. So the moderators are going to be, either removing comments, or timing out people who are creating conflict that doesn't pertain to what we're talking about, essentially, right? That's all. If it's creating chaos and it's not part of what we're talking about, then the moderators are going to step in. If there's any personal attacks, of course, my moderators are going to step in. That's everybody should know that. It's a no-brainer from day one if you've been watching my channel. So none of that. So look, just be mindful of what you're saying. Try to keep it on point. And if you do start to get off point and my moderators, remove a comment or put you in a timeout, just understand that there's a reason why, and you've been warned. Okay, so just wanted to say that. So let's please keep it on point, and so everybody can enjoy this, and everybody can come here and feel like this is a place they can come and get information without there being issues. Wow. Anyways, so moving on. Kathleen Zellner this time got to respond to the state. Obviously, last time the state filed, with the testing motion, the state filed its response, and the decision was out so quick, Zellner never got a chance to reply this time. That wasn't the case. She did get to reply. We got to see it today, and it was pretty darn interesting. So very interesting, and I got to say, a little entertaining, honestly. It's there's a few things in there that I'm glad I saw her go after, particularly the one thing that I wanted her to go after, she did, and that was the way that the state was talking about Avery dropping his appeal in favor of the pursuing the testing and everything and all that, and never mind the fact that the motion she's bringing is pointing out that they've already gotten rid of that, basically. And they're just skipping right over that and basically never ever approach the issues at hand here. They never ever even come close to doing it. They don't talk about whether or not the bones have been returned to the haul box. They don't talk about anything. They don't talk about pages 1114 and 1115, I think it is, of CASO that basically told everybody what happened with a lot of those bones in the quarry piles. It's possible human bones, the ones that Kratz couldn't spend 20 seconds on. So so we see in that document was withheld from Stephen. That document, it was withheld from his attorneys at the time, his appeal attorneys. It was never sent over. They were withholding. They're hiding things again, just like the CD, which she talks about quite often in this reply, because it's a very similar situation where this was just not handed over. It was not handed over to Stephen or his attorneys, and it should have been. And so that's one of the main issues here at hand. And there's a lot of other brilliant things, but I'm going to go ahead and give you guys a chance to speak real quick.
Well, welcome again, Tracie. So glad to have you talk about the legal stuff. I really enjoy your insight and opinions and your fantastic legal research, and always great to have you come in and talk about legal issues on Erekose's channel. For those of you who haven't seen Tracie in the past, she's got a Facebook group called Basically a Lawyer, where she's been following the legal issues of Stephen Avery and Brendan Dasney for years. not just since Making a Murderer 2 came out. She's been following this case for years from the legal perspective. She also has a YouTube channel, I think, that goes by the same name, basically a lawyer. She's got basically an investigator on her shirt today, but it's
basically a detective. Yeah.
yeah, basically a detective, but basically a lawyer. But welcome and thank you. That's all I had to say.
Yes, thank you for being here, Tracie.
Well, thank you. That was very nice. You didn't have to do all that, but thanks for having me. I actually had not planned on doing a video on this because I thought it was pretty self-explanatory. I said that she just essentially wanted to tell them to sit down and shut up. That was about it. So, so when Travis mentioned that you guys were doing one, he asked me if I wanted to come on, and then I said sure. So I'm really here to just answer any questions you guys might have if you want me to expand anything. But it's it's only 9 pages, so
yeah, it's pretty short. It's not a whole lot to it. Yeah, but but what's in it is fun. So
I did enjoy it.
Yeah. So to get down to it, let's go ahead and I'll screen share it, and you guys can follow along. All righty. So this is the motion, folks. Obviously filed today, February 1st. And this is the reply to the state's response. This is how things usually go, folks. For those of you who didn't follow along with Brendan or don't know, this is the way it usually goes. Zellner filed her motion. The state got to respond. And then Zellner now, because she did it in time before the decision came out, she was able to get in her reply. So she was able to reply to the state. And that's generally how it goes with the appeals courts. Or at least that's the way it mostly went with.
Yeah, with the motions for sure. That's what the rules provide. And then it's similar and the names remain the same when we actually get to a briefing schedule. But yeah, it's kind of confusing, but I'm glad you pointed that out. Erekose, there's a response that's filed by the state and then a reply. So easy to get them confused, but
yeah,
the reply is what got filed today by Zellner.
To help everybody keep it all straight, because these things come flying in, and I know you guys have sometimes a little trouble processing. I know it took me a while to get it, but after following Brendan through the federal district courts, I now understand kind of the dance. I certainly am not a lawyer, but and I haven't gone to law school, but I do understand the dance. I mean, I've seen enough to understand the way the dance works, sort of. So anyways, moving on here, she just starts out talking about
I don't know that.
Oh, easy there. She starts out talking about the state withholding exculpatory evidence, which would be the bones given back to the hall box, essentially. She talks about the CD with the images of violent porn and all that stuff that was held in Tom Fassbender's personal custody for 12 years. Obviously offering that as support that the state is hiding things, that this is now the second thing that they've been hiding. So she's just kind of bringing up the CD so that the appeals judges consider that. And something interesting down here, you guys remember me talking yesterday about how galling, it was to see the state suggesting that Avery should drop his current appeal to pursue this whole claim about the bones being destroyed and everything in violation of statute. They're basically saying he should drop the current appeal for that. But as you guys know, last night in our video, Travis and I made it pretty clear that the destruction of evidence is a 97406 claim, and therefore it's not a different, as Tracie will put it possibly here later, it's not a different procedural mechanism, which is why the testing got denied. Okay, so the testing was 97407, different. So that's what I mean by a different mechanism, because it's a slightly different statute. So the fact is, though, now that she's bringing this motion, it's about the destruction of evidence, and that makes it an 06. And that means it's compatible, basically, with the claim that's currently in the appeals court. And as we talked about last night, judicial efficiency or there was maybe another word Travis used, but basically it just means, why would you want to drag this out on 2 successive appeals when you could just put it together and have finality quicker, right? Because I know Tracie likes to talk about finality too, and the courts love finality. So that only makes sense as well. So to go through this part real quick, I just found this interesting that she addressed it. Instead, the state carried on in its charade of concealment by claiming that Mr. Avery could voluntarily dismiss his pending appeal. The state's response specifically stated, the state notes that Avery has the option to voluntarily dismiss this appeal if he wishes to litigate a Wisconsin statute 97407, which is testing, which is not what she's asking for here. Okay, just want to make that clear. Motion now. If he chooses to do so, and if the circuit court grants the DNA testing, that produces exculpatory results, it is possible that some or all of the issues raised in Stephen's current appeal, the 97046 that's currently in front of the appeals court, will become moot. So they're trying to say that if he goes after that, then maybe all this stuff that he's appealing right now won't even matter. Like I don't know, like trying to offer it like a carrot, possibly, like, I don't know, not very enticing, but it seems like maybe that was what their thinking was. But moving on, she moves on to
go back up to page 1, the first paragraph.
Page 1, first paragraph. Okay.
Or page 2.
Sorry.
First paragraph, right under the introduction.
The state's response. Go ahead.
Yeah. Okay.
The state. Oh, if you want to, go ahead.
Right under the introduction.
Okay.
So just this first paragraph, this is for the people that were like me and Tracie, get into this beautiful appellate language, but just listen to this first paragraph for a second. The state's response conveys an attitude of impunity for its past actions of withholding with exculpatory evidence and its current action of continuing the concealment of its destruction of potentially exculpatory or useful evidence.
Right.
I'm telling you, there are very few first sentences of a brief
that resonate like that?
Of a pleading that set the tone. Then the next paragraph, I just wanted to point out, last sentence of the second paragraph, this court did not accept that disingenuous response then, and it should not now accept the state's current disingenuous response, which echoes the same argument. Y'all don't know what the word disingenuous means. That's lawyer talk for, they're damn liars. In Texas, if you use the word disingenuous, you better have the goods, because you're either going to get a bar complaint or an ass whooping. So that is extremely strong language.
Right.
And then I like at the bottom of page 2, I'd love the way she writes, or whoever writes for her. The last sentence of 2, the state carried on a charade of concealment. You read that leading into the quote,
right.
But
yes.
Beautiful, beautiful language. And then going to the next page, there's the quote you read. And just to remind everybody, she was quoting from the state's response back in December, and for the motion for DNA testing. And then she's going to weave in here in the next couple of pages. But, she's pointing out 2 things here, what their position was back then, but then she's also, by doing that, showing that, they repeated a lot of what they said in their response last time in this one. So
right.
That's all I had to comment on that. I don't know if Stacie has to add anything on those sections.
Tracie, you mean?
Tracie, did I say Stacie?
You did.
Yeah, you did.
Oh,
That's okay, though.
That's all right. We love Stacie Seabrook too. So
that's okay. My mother-in-law called me Stacie for like the first 5 years I was married.
Oh,
so
that's
fine.
funny.
Yeah.
Okay. Well,
my husband actually still calls me that because of that.
Oh, wow.
Yeah. So, there's not much more I want to add to that. There's really, like I said, it's more just the language of telling them that, that a lot of stuff that they're saying is it's just flat out ridiculous. There's not a better word
Right.
for it.
It's
something she couldn't address before, but for them to say that, well, if you want to drop it and pursue that claim, it's like, we'll understand Like, it's the dumbest thing they could have said, because it's not only disingenuous, it's mocking.
Right. Yeah. Right. Yeah. That's what or taunting.
Yeah,
Almost,
it's
right?
a very
Yeah.
mocking or taunting tone, and it's like, so it's like, don't be so confident. I mean, granted, there's a whole different issue with whether, what's going to happen to this claim after it gets remanded, but still, like, just on this, it's like, like, why are you? They have this air of superiority about them, and when it comes, like, when there's something like this that they file that is just so bad,
Mhm.
it's I
Right.
mean, when they wrote the response, it was just so poorly written, it was poorly constructed, it wasn't even supported by the facts, anything. It's just like, I don't know. So it's just weird that they can still have this, like I said, this kind of like superior attitude while supplying something so inferior.
Right.
Right.
And just like
But
Tracie was saying and pointing out, sorry, go ahead. One more thing.
no, it's just, I said, but that's kind of a theme that runs through this case.
Right.
They always seem to like to pat themselves on the back about how awesome they are when they've really done a terrible job.
Right. Exactly. And just like Tracie was saying, those things about the state and stuff. And so Zellner here, after this condescending little bit that the state, is suggesting that Avery should drop his appeal or whatever, right? She finds that somewhat condescending. So she puts this paragraph following those quotes. What the state fails to mention in its helpful guidance to Mr. Avery is that it facilitated the destruction in 2011 of the very evidence that Mr. Avery would be hoping to test. If he was so foolish as to voluntarily dismiss his appeal. I mean, she's just like going, yeah, it's a ridiculous statement on its face, but beyond that, it's just it's just not. It doesn't make any sense. It's it's illogical essentially,
Right.
and I love it. I love it.
Yeah, and as Tracie just pointed out, she didn't get to file a reply last time. And while we never really thought that she would ever consider dismissing an appeal to pursue DNA testing, no one, not hearing it, not seeing it in black and white. Well,
I know
this
some people that
paragraph
thought it
here
was abandoned.
says, only a fool would do this, and so I'm glad she had an opportunity to do a reply this time, because it.
Oh, it's a thing of beauty. I love it.
Yeah.
So yes. So if we move on, let's see. The state has not been prejudiced in any way by the delays granted to Mr. Avery. That's them complaining about the fact that Kathleen Zellner is trying to drag this appeal out indefinitely, wasting the court's time. Yeah, wasting the court's time.
Well, that's a stupid thing to say too, because Steve's in prison. This getting dragged out is only good for them. The only person that it doesn't help is Steve, so for them to act like you're inconveniencing us by dragging this out, they'd be fine if it dragged out forever, because that means he's going to stay in prison.
Right.
Yeah. So again, it makes no sense to say that.
It would suggest that they actually fear that the longer this whole thing goes on, that they're afraid Zellner's going to actually hit, oil, I guess, as it were. Like she's actually going to strike, something sensitive, something that's going to, land, like this might. I think this has a pretty darn good chance. But yeah, so I mean, it almost suggests that they fear that they fear something out there. Maybe it may be something specific to them. That they know about, and they're just hoping never surfaces, possibly. I don't know, but you'd think it would have surfaced by now. But
well, as Tracie's pointed out in some of her videos, in a recent one, that Zellner has gotten cases reversed where she's had an evidentiary hearing, she's had a prosecutor up on the stand in connection with a Brady motion. She lost that Brady issue, but she developed on cross-examination additional testimony that ended up getting the guy exonerated. And so I'll tell you what they fear. They fear an evidentiary hearing with her.
Right.
You don't have to read too many layers into this.
Right.
They're, they do not want her to have an evidentiary hearing. And, there can be many layers under that, but, let's just start at that point. That's kind of my take on it. Yeah. What are they hiding? What do they fear? They don't want to get up and be subjected to cross-examination because they've seen what she's been able to accomplish in the past when she gets a prosecutor on the stand.
Right.
Tracie, what was the case that she had where she got the prosecutor up there on a Brady and
Brian Ferguson's case.
Ferguson?
Yeah, it was during his evidentiary hearing, and she ended up losing on everything she actually presented in that hearing and that appeal. But while on the stand, the district attorney accidentally admitted that they had supplied one of the witnesses with the article that he claimed to have read himself, and that's how he knew it was Ryan or whatever. And so when he accidentally said that, then she had a Brady violation there for them withholding that information that the district attorney had actually been in contact with the witness. And it supplied him even with the article that he was referring to. And that's ultimately what led to Ryan's conviction being overturned.
Oh, it's interesting. See, it's interesting. Sometimes
She
it looks
also
looks so sometimes serendipity is part of
right. But she
curing
also got
wrongful
somebody
convictions.
she got somebody to confess on the stand too once
Right.
in one of her cases. Yeah.
Yes,
So
that there was a lady that she got that
Mhm.
lady, that elderly lady, to admit to killing her husband so
Right.
that the young kid wouldn't get the death penalty, I think
Right.
it was, right? Yeah.
And I'm
yeah.
not saying that would happen, but you never know what you can get. When I was on last time, we talked about how everything just leads to more questions. We're never getting any answers. This would actually be the first opportunity to get some answers.
Right. So I'm going to move on to this bit here because I think this is really interesting here. So let's see. The state wants this court to turn a blind eye to these actions and focus instead on Mr. Avery's actions in seeking a second delay in filing his brief. Given that this case spans 12 years post-trial, the request of an inmate serving a life sentence without parole in seeking 2 delays based on recently discovered, suppressed, and destroyed evidence hardly constitutes a threat to the orderly administration of justice in the state of Wisconsin. If Mr. Avery waited to raise this current claim until after his appeal was concluded, the state would undoubtedly argue that he had failed to show a sufficient reason for not raising the issue sooner. You understand why it's getting mentioned now, everybody? That's why. The state will totally try to screw her and say, you should have said something sooner. She said something sooner. That's where we're at, folks.
That was the analogy last night we used, with Lucy holding the football for Charlie Brown,
right.
And come on, kick it. No, you're going to pull it away and I'm going to fall on my back. No, I promise I won't do it this time. And, we all know how that works out. But going back to that top line of that page you just read, the other thing we talked about that Tracie alluded to earlier, their response, and we talked about this last night, that this appeal is languishing.
Yeah.
Never, I don't, maybe Tracie's seen it. You usually don't see the state use the word languishing because there's only, in this appeal, realize there's 2 men languishing, but in this appeal, the only person that's languishing is in a 6x5 cell, 10x6 if he's lucky, every night, every day. There's only one person languishing here. It's just utterly ridiculous. And I think you'd be hard pressed to find in a pleading filed by the state that they were trying to take the silly position that an appeal was languishing. Appeals don't languish. They sit, they do whatever. People languish. Maybe that's the problem with the AG's office, is they don't understand the difference between what a person suffers and a piece of paper sitting in a clerk's office.
Right. Certainly. Let's see. So, okay, as a result of the state's actions in concealing and withholding the Dacianda CD, right? The first thing they held Tom Fassbender's personal custody for 12 years, right? And then the concealing of the return of the bones to the Halbach family. Mr. Avery has been forced to delay his appeal, and therefore his quest for a new trial and eventual freedom has been delayed. So she's flipping it around on him, where she's like, Mr. Avery's the one really suffering here, and he's trying to move this forward so he can work towards, setting his wrongful conviction to right. But this constant concealing of things by the state and us having to find them and go seek them, which they're not supposed to have to do, which I think she does point out later in this motion. So, but that's what the state's doing, and she's pointing it out here, and that's the issue at hand, really. That they're holding up Mr. Avery, and like Travis was saying, Mr. Avery isn't inconveniencing a piece of paper over at the appeals court. So that's how that goes.
So she's going to go into why Mr. Avery and her not being dilatory. Any comments on what we've covered so far, Tracie?
No, just more what I said before. I said the only time that the state ever complains about a delay is when the lower decision was adverse to them. So they're not going to complain. The longer this appeal plays out, the longer Steve sits where they want him to sit. So it's an argument that is masking something else because it's not a legitimate argument.
Right.
It is not hurting them. It benefits them for this to not move forward. Because the last thing they want is this to get to the end of it, and all of a sudden, boom, there's a hearing, or it could be something. Relief could be granted, his conviction could be overturned. They're in no rush to even possibly get to that point.
Mm-hmm.
So, whether they're making this argument to try to draw away from something else, or if they're just making this argument because they have nothing else to complain about, I don't know.
Right.
But they sound like I told Travis earlier. I had said that if it was possible to put down on paper what a stomping toddler would do, if you could express that on paper, that's what they would file. Because that is exactly what they're doing.
That's brilliant. I love
it.
Freaking love it.
Yeah.
Exactly. It's like if they want to stomp their feet, they want to pound their hands on the ground and throw a fit. And that's essentially all they're doing by making this ridiculous argument about the delays, because trust me, they don't care about it being delayed. It's good for them. So why are they even making that argument? And I think it's because they had no other argument. Everything that they put in their response was bad.
Yeah.
They
avoided the actual issues that were being referenced here.
Right. Well, see, and I have a different opinion on that. I had said that, I thought people were making too big of a deal that they didn't address the bones, because this is a motion to remand the case. This is not a motion for relief on a due process violation.
Sure.
That's when that stuff
so they're
has
not
to be
trying to
addressed.
explain that right now? Okay.
What? Oh.
So you're saying they're not trying to explain that right now, basically?
No, they're not. But
right.
the thing that I forgot to mention when I did my video, and I put it in my group today because I wanted to be clear about it, is that obviously the best defense to why the case shouldn't be remanded is if they had the bones. If they had them.
It's a false accusation.
So,
right.
So yes, that is the absolute best defense to this argument of hers, is to say, what are you talking about? We've got them.
Absolutely.
Okay, we didn't get rid of anything. Well, clearly they didn't make that argument. And if they did have them, they would have made that argument. Now, we already know from CASO that they don't have some of them, but this is essentially them confirming it. And in my mind, that is even begging more for a hearing then, because now you're essentially admitting that you don't have these bones anymore. So you're kind of helping her with her claim that this needs to be evaluated. We need to pursue, the truth about the facts surrounding this, so that we can get to the bottom of it. And so it's a strange. All of their arguments were nonsensical to me. They didn't make any sense. And I told Travis earlier, it's like in Kathleen's motion, she threw the Constitution at them, and they threw procedure back. Well, in the reply, she just threw the Constitution back at them again. You know, it was like, it's like, you want to try to distract from the issue here. Well, I'm going to throw it back in your face. And so even though they weren't required to actually address the bones, because this isn't a motion for, that's not what the motion is. The motion
Right.
is to remand the case, and they're trying to use procedural reasons. But there is something to be said for them not using what would be the very obvious reason to, you know, argue against it. And that would be like, well, they still had them. So by saying, but their silence suggests they don't have them, and therefore the court should still then be like, well, why wouldn't you just argue you had them if this wasn't a problem?
Right. Right.
You know,
Absolutely.
so again, the argument doesn't, I understand why they did it this way, because they're trying to just avoid it completely.
Yeah.
And they're not required to, but again, sometimes silence speaks just as much.
Yeah, absolutely. All right, I'll let you take this one, Travis, since you were kind of fired up about it.
Where are we at?
Bottom
dilatory?
page 4.
Yeah.
The dilatory.
So here she lays out why these absurd suggestions about languishing appeals and perpetual delay. She addresses this directly, points out that they keep raising this. And then she answers it quite simply. This suggestion is belied by the record, including the instant motion. Mr. Avery has pursued 2 motions to stay the appeal and remand for further proceedings, and 1 motion to supplement the record. The motion to supplement the record, she's referring to the CD disc, on which this court ordered proceedings in the circuit court. Mr. Avery maintains that each of these motions raised meritorious claims for relief based upon issues relating to his original 97406 motion and supplements. Over to page 5. Indeed, Mr. Avery has not filed these motions to delay this court or unduly postpone his appeal. Instead, he filed his motions to apprise this court of ongoing due process and discovery violations. That's a pretty bold statement right there.
Yeah.
And that will go unanswered by the state, by the way. To apprise this, they had an opportunity to say, no, you're wrong. You know, there's nothing going on with these bones, but they just, as Tracie said, they just threw back procedure at her.
Right.
She says, needed to apprise the court of ongoing due process and discovery violations that only after months of litigating Mr. Avery's post-conviction motion and his appeal have recently been discovered. These motions are not intended for delay. I don't really have anything to say beyond that. I think that says it all on the issue of, you know, whether this thing is languishing or not.
Right. And for those who want to take a negative look at Zellner and believe this crap, this tripe that the state is trying to put out, look, we have this reason why, basically, you know, that they are continuing to be bad humans and not treat fairly. But then we also have the fact, you know, that
Falcon's still asking, why doesn't she drop this appeal then and pursue this issue? We answered that. Yeah, we answered that. So Allie, Amber, if he continues on with that, he's not being serious about it. I want you to take care of it. But we just answered it right there. Okay, next, Roman numeral 2. Take it away, Erekose.
Alrighty. This motion for stay and remand is analogous with Mr. Avery's previous motion to supplement the record in connection with an alleged due process violation. Mr. Avery has previously moved this court for a remand to the circuit court to litigate motions to supplement the record with a previously withheld CD containing unique violent pornography search material from the Tracie computer. In that motion, Mr. Avery asked this court for leave to supplement his 97.
Time out. Stop.
Go.
Denise, Allie, get Falcon off of there. Just get him out of there.
Yeah, remove him.
Okay, roll on, baby.
All right. In the motion, Mr. Avery asked the court for leave to supplement his 97406 motion with the content of the CD containing the forensic results of the ASCII computer. Neither the CD nor its contents had ever been produced to Mr. Avery or his defense team in any stage of his criminal proceedings.
Stop. Why is he still in there? Allie, Amber, where you at? Get him out of there. Thank you. No, get him out of the conversation. And then we'll start back up. Don't delete the message, delete him. Good. Okay, roll.
How to use her on this channel? How the hell do you boot? I don't think I want to talk to Falcon anymore about this later if he couldn't respect what we said. But anyways, moving on.
Time on it. Roll it, baby.
So, in that instance, this court retained jurisdiction but remanded the case to the circuit court for Mr. Avery to file a supplemental post-conviction motion. Allegations relate to issues already raised in the underlying record. The same outcome is appropriate here.
Okay, so this gets back on track here. This motion, this Roman numeral 2, motion for stay and remand is analogous to his previous motion to supplement. Okay, so this is the computer stuff, and she's trying to show, even though she doesn't state the specific timeframes, but we talked about this last night, it only resulted in about a 60 to 90 day delay when the court sent back the issue so she could file a motion, a Brady motion on the computer stuff, including the CD and whatnot. That was it. And, now that issue is up with all these other issues. They don't have to be dealt with seriatim, one after the other. As with all post-conviction motions like this, including even in the federal system, appellate courts, trial courts that hear, these post-conviction motions, whether they're called, a writ of habeas or a 97406, or in the federal system, a federal writ, they want to get it dealt with at one time. Bring it all at once. We want to see everything. Don't come to us piecemeal. We don't like to handle it like that. And I know Tracie has commented upon this in the past, but if you could add to that, Tracie, why she's analogizing to this previous motion, you think?
Well, I actually don't agree with that. So,
okay, no, that's fine. That's fine.
Because I understand what she's trying to say, and it's actually moving into the next part. But when it came to the CD issue was truly part of an existing Brady claim that was already in front of the Court of Appeals. That's the reason she didn't file a motion to remand. She filed a motion to supplement the record because the CD was additional supporting evidence to that existing claim. And they remanded it for that. This is not an existing claim that's already in front of them. And that's kind of what the state is saying, that they're arguing that since it's not an existing claim, that she can't remand it back, but that's not true. Now, I don't want to get ahead of us, but she's explaining how this fits and why she can do it. She's saying that it's in the underlying record. So I still think it's definitely not on point exactly with what the last situation was, and I don't think this will change whether it should be remanded or not. But I would have liked to have seen it a little more squarely on it if she was going to refer to it that way. But I think they are different issues. But that doesn't mean that one should have been remanded and the other one shouldn't. I still think they both warrant review. It's just that I probably wouldn't have used that argument, that exact argument.
Right. Okay, so
are you saying also, Tracie, her heading says the motion for stay and remand is analogous to his previous motion to supplement.
Right.
Are you saying you don't think it's that analogous?
It's not directly on point, it's not as on point as she's making it, because again, that Brady claim was already in front of the court and she was looking to supplement it with additional information. This is a whole new claim.
Yeah.
It's not in front of them. So, and that's the argument that the state was making. And so she's trying to, I think she's just trying to combat what the state's saying by trying to kind of shoehorn into fitting it the same way. Under statute, she doesn't need to do that.
Right.
But the statute allows for it. So she didn't need to do that.
Yeah, she's shoehorning it to get in one more example of, what did she call it? You know, them hiding evidence or suppressing evidence.
Right.
And so I think, yeah, I agree with you. It's tenuous. It's not really analogous. It's completely different procedurally, just like the motion for DNA testing is that we're going to get to in the next section. But it's one more way that she can bring in evidence, and her language is way better than mine, of state misconduct, facilitating the destruction of material evidence, charade of concealment. It gives her one more example. I agree with you on that.
I think that this is what I mentioned before we started, though, that I'd said that when the state had filed their previous response that she didn't get to reply to, they had said that the 97407 was a separate statutory procedural mechanism. And she didn't address that. And I think that would have been a more on point thing to address, the fact that this is not a separate statutory procedural mechanism. It's the same one, just a new claim that she's adding to the 97406. This isn't a completely different statute. She's not initiating an action under a separate statute.
Right.
She's
Not
initiating
a mechanism.
Right. She's adding a new claim to an already initiated action of a statute. That is more analogous to me than the actual circumstances of the last remand.
Right. Yeah, I agree. All right. So moving on here, let's see. Because the court originally remanded for scientific testing so that test results could be included in Mr. Avery's 97406 motion, the state was on notice that Mr. Avery intended to test the suspected human pelvic bones recovered from the Manitowoc County gravel pit. Mr. Avery's 2015 appeal concluded on September 8th of 2016 when this court remanded the case to the circuit court for post-conviction scientific testing of evidence. Among the evidence Mr. Avery asked the circuit court to test were the suspected human pelvic bones collected in the Manitowoc County gravel pit under Calumet County property number 8675. Therefore, the state has been on notice that Mr. Avery wished to obtain the Manitowoc County gravel pit bones for several years. The state fails to acknowledge that Mr. Avery is appealing the circuit court's error in abusing its discretion in denying Mr. Avery's motion to vacate its October 3rd, 2017 order of allowing additional scientific testing. So that looks to me, I think I missed that the first time around, but she's basically saying we did mention this in our motion, essentially, or we mentioned wanting to test these bones.
Right. And that's why she's saying it's raised in the underlying record.
Right.
It's kind of buried deep in there. It's not directly regarding that what's under appeal right now. The results of that testing are under appeal. And so she's basically just saying they've known for a long time that we wanted to test these bones.
Right.
That's all she's trying to tell them.
Sure.
Is that this is not new information to them that we wanted to test this. They didn't just find out about this with the, motion from last month.
Right.
They've known for a couple of years now that she wanted to test these bones. And at any time they could have told her then they did not have them. But yet,
and lo and behold, now
Fallon,
documents surface showing us, oh, they've been given away.
Right. And Fallon went so far as to even agree to the testing at one point. And we know Fallon was involved in the disposal. So again, that's why, where the word disingenuous comes in again. It's like, why did you make an agreement to something that you should have known you didn't have? So that's she's just trying to kind of point that out. But again, it's a little tenuous as far as the how it's related to the actual appeal itself.
Right.
And it doesn't have to be. Again, I want to make sure that that's clear. It does not have to, despite the fact that the state repeated over and over again that remand is only allowed on a specific issue in the current motion in front of them. That is not true. It doesn't say that in the statute. It just says
new claim. They said new claim.
And it doesn't matter. You can have a new claim. It can be remanded for a new claim that is not before the court. The case law says that. So the fact that they kept saying it it's just not right.
Right. I mean, and it makes more sense since they are the same mechanism to kind of group them together and have them taken care of in one go, right? That's really
Like
the
you
efficient
said,
way.
it's in in the spirit of judicial economy. You're
Right.
like, again, why would you want to go through this entire appeal and then
another
and then have to start a new one and go through this whole process again? How is that more economic?
Yeah, I agree.
It's not. So again, that's just another argument that's just doesn't hold up as far as making any sense goes.
Right.
But so I mean, but she doesn't. That's the one thing, like, she doesn't need to really have this support on the record of why she can do this. She can just do it because it's newly discovered. That's why.
Yeah. Right. Okay.
So another shout out to the the researching madwoman of Wisconsin, Tracie, found a case that she sent me the facts on. Unfortunately, it's an unpublished decision in Wisconsin, but she found this Gladney case that we talked about last night, where someone raised a new issue, and they said, "Yeah, we'll remand it." Now the trial court, they had a hearing, an evidentiary hearing, and the trial court ruled against them, but it went up on appeal. But the earth didn't stop moving, the ground didn't open up, the criminal justice system didn't come to a screeching halt. It went down, had their hearing on this new issue of Brady, and then consolidated it all up. But yeah, they said, I don't know how many times we counted new issue last night, new claim, and like Tracie just pointed out, what we tried to point out yesterday is that's not what the rule says. It shows,
no, it doesn't.
Says show good cause, and it's the court's discretion.
Right.
Yeah, it doesn't even say show good cause. I think that's just what they took from the court's last denial. But all it says is that it can be remanded to basically for specific issues. The state kept saying it can only be remanded for specific issues regarding what's in front of the court. That's not what it says. It doesn't say that. And then you mentioned the Gladney case, which is an unpublished per curiam opinion, so it can't be cited. But State versus Redmond can be cited. And that very clearly says if a defendant wants to assert additional grounds for relief, it's not saying it's new, but same thing. Additional grounds for relief that have not been addressed through the original post-conviction motion, he can petition this court to remand to the trial court for consideration on those specific issues. That's, and the reason there isn't a lot of case law on this is because it's a statutory right. It's something that you're allowed to do by statute. So you don't really need a whole lot of case law to spell the statute out for you. One case will do it.
Right.
And then I don't know when you want to get into it, but I mean, obviously I said something about the other cases, but I can wait on that if you want to address that later.
We're going to talk about that right at the end of section 4. And I made a note here to remind you to talk about Redmond some more there too. Perfect. Awesome.
Okay, so moreover, the Manitowoc County gravel pit bones were a subject of the September 18th, 2017 agreement, wherein the parties agreed to further scientific testing. Thus, the state's claim that the instant motion is devoid of foundation in the record is specious. Mr. Avery has been petitioning.
Stop. What does everyone know what specious means? That in Texas we'd say that's bullshit. Okay, specious. Specious argument.
Unnecessary information argument.
Yeah. Right. Okay. All right. Well, Wisconsin.
How about dubious?
They got manners. They got manners out there. Okay.
All right.
Okay,
Mr. Avery has been petitioning the circuit court for testing of the Manitowoc County gravel pit bones for years. With such a foundation in the record on appeal, the state's response in opposition to Mr. Avery's motion should be denied. You want to read 4? Go ahead, buddy.
Okay, 4. I'm not going to read it, but the state should not benefit from concealing a report, failing to give notice, and facilitating the destruction of biological evidence. Wow, what a great header. And she does cite this Banks case. Now, not really for any legal proposition, but sometimes you cite a case just because it's got language in it. You know, you can't shout fire in a crowded theater. Pornography or obscenity, I can't define it, but I know when I see it. So this is one of those catchphrases. The state's opposition to Mr. Avery's motion is tantamount to asking this court to sanction a rule where prosecutor may hide, defendant must seek. And they cite the Banks case.
Yeah.
Such a rule is not tenable in a system constitutionally bound to accord defendants due process, citing this same citation. That's worth another read right there. Such a rule is not tenable in a system constitutionally bound to accord defendants due process.
Absolutely. In other words, it's against the grain, folks.
Yep. And then the next paragraph, she takes a dig, a major dig at the state for not denying any of these due process violations she brought up in their response to her original motion. The state makes no effort to deny the due process violations Mr. Avery alleges, i.e. the state concealed a police report, failed to give statutorily mandated notice to Mr. Avery. Now there's the statute, there's the preservation statute. See how she wove it in? How many times did the state mention the preservation statute in their response? What did we count? Zero. Yep, she hit him with procedure. Mr. Avery alleges that the state concealed a police report, failed to give a statutorily mandated notice to Mr. Avery and his attorneys of its intent to destroy biological evidence, then facilitated the destruction of the same evidence. And then here's one of your favorite lines in the entire pleading, and then we'll start talking about some law after we comment on this paragraph. The state should not now reap the benefit of its past statutory and due process violations. Such an outcome would contravene the sense of basic fairness inherent in our justice system. Beautiful words.
Yep.
And one can only hope. So I don't know if y'all have comments on that section, paragraph 4, and then after that, we'll let Tracie talk a little bit about maybe some missed opportunities to discuss some case law.
Basically, that last sentence is the only thing I would have basically said. So, Tracie?
The first thing I do want to mention is that I know a lot of, I saw some people, like, obviously on the opposing side, that were going on about, well, the bad faith, she's not going to establish this, blah, blah, blah. That is not at issue here. We are not to the point of deciding if she's going to win this claim or not, or if it actually is a due process violation. We are at the point of saying this needs more looking into. That's all we are at. So I feel like some people, especially again on the opposing side, have jumped way far ahead of us here. It's like we're talking about what he should be entitled to as far as an evidentiary hearing, being able to present the claim. We are not to the point of talking about him winning it yet. You know, like that's later on once we have more information. Until we actually get some answers, it's really hard to say for sure, you know, the strength of the claim itself. That's not what this motion is about. This motion is about, like, saying it's fundamentally unfair for them to do this, and we should be able to present this as a violation of his rights. That's what they're saying. You know, so I just want to make sure that that's clear, because it's just like with the last one, when the court denied the remand and everybody kept saying they denied the testing, and I kept saying, no, they didn't. They didn't deny the testing. All they did is deny the remand to do the testing right now.
Right.
They can do it later.
Right.
Right.
Yeah, I was big on trying to explain that to people too, as well. So
yeah, people seem to get confused because since Kathleen puts these arguments for the due process violation in her motion, they think that's the case at hand here, and it's not. That's not the issue at hand. The issue at hand is her just presenting enough to show that we need to remand this case and we need to get some more facts here. That's all she has to do right now. So I just want to clear that up. And even though that's mostly something I'm seeing from the guilters right now, it's not from the supporters so much, but from the guilters are just saying like, she didn't even, present this and she didn't present them. Like, she's not supposed to. This is not a motion for relief due to a due process violation. This is a motion to remand to pursue a claim of relief for that. That's all.
Right.
So when it comes to the case law, and I just said I was disappointed that she didn't add this because I just figured while she was at it, she could have pointed out that they lied about the case law. And because, okay, this is me. That bothers me.
Right.
Some of the other stuff doesn't bother me, but that bothers me.
Right.
And I keep all the attorneys honest. I've called Kathleen out in some of her questionable citations before. These are not even questionable. These are just flat out not saying what they say that they're saying. And in the response, the state says that in all of the published cases addressing staying an appeal and remanding to the circuit court for additional proceedings, the remand was to address a specific issue related to the claims already before the Court of Appeals. Well, since I already cited State versus Redmond, clearly that's not all of them. They didn't list all of them because that's one right there that is not doing what they say it is. But they listed Farm, Yang, and in the commitment of Matthew. And all three of those cases, what they said again was that it was remanded for a specific issue related to claims already before the Court of Appeals. Lie. I won't go into all the details. I did that in my video, but in every single case, when this motion to remand was filed, it was for an issue that was not yet in front of the Court of Appeals.
Right.
It wasn't. So, I mean, it's like one of them was specifically about newly discovered evidence. He wants to he filed a motion to remand to be able to present newly discovered evidence in the circuit court. Okay. You can't get more far off. That's like opposite of what she's saying it says. So
Right.
I just couldn't believe that they flat out, I mean, and it's not like they're tricking anybody. The court knows these cases.
Right.
They know these cases. So it's just really, again, I just keep using the word nonsensical. It's nonsense, but it doesn't make any sense. Like nothing they argued made any sense. And so I just wish Kathleen had taken the opportunity to say, oh, by the way, all your citations, liars.
Yeah. She did. She did. She said disingenuous. Travis pointed it out.
Disingenuous.
Because I would really like to see when people are, when the other side is debating about this, I'd really like to see an argument for that. I would like to see a defense to that, to say that, and they can say, oh, Kathleen's done it. She doesn't flat out lie. She truncates things and she might twist things a little bit, but she doesn't flat out lie about what they're saying.
Right.
This is just a flat out lie. I mean, she said that the claims were already in front of the court, and in none of these cases was that true.
Right.
So, these citations actually help Kathleen more than they help the state. So that's the only thing. I was just disappointed because I really would have liked to see them called out for that because, that just goes along with the disingenuous, things they're saying and doing. So that's all I really wanted to mention about that.
Alrighty. So to move on to the conclusion here, basically, wherefore undersigned counsel respectfully requests that this court enter an order staying this appeal and remanding the cause to the circuit court for proceedings to determine whether the state has violated Wisconsin statute 968-205 and Youngblood versus Arizona, dated the 1st of February 2019.
Can you get rid of the document and put us up, and then we can answer some questions? And while people are formulating their questions, I thought it's always a good time, no matter how many times you say it, they're going to ask, and let's give Tracie first crack at it. What are the next steps? What happens from here?
Well, the Court of Appeals has to rule on this issue. I know I said in my video, I said that the District 2 Court of Appeals judges operate out of the Waukesha County Courthouse. That courthouse was actually closed both Wednesday and Thursday. So if the judges weren't in their offices, then that could slow things down a little bit. And I know people made a big deal about how last time the court ruled right after the state filed, and it looked really weird. Well, it was on that 11-day deadline. So it's more likely the court had already planned on filing their decision, and the state just squeaked in their response under the deadline. So there's no reason to think that they wouldn't rule within that 11-day window again, especially since they have heard from everybody. Last time they probably gave the state the 11 days to respond if they wanted to, and then just file the ruling. This time they probably don't have to give that much longer. They never have to, but they were probably just giving them the chance. So this time, since they have everything, I wouldn't expect it to take any longer than that. That would be Wednesday, I think would be 11 days. So I would expect by the middle of next week. And then there's other things, whether the motions judge needs to present it to the entire panel, if he's having issues deciding. I don't think it's that complicated. So yeah, I would say early next week, there should be a decision.
Right.
Obviously, never know what'll happen, but they did have 2 days where they weren't in their offices. So
Right. Well,
that could have.
my thing
things a
is
little bit.
in that last paragraph, she's obviously asking him to remand it. Now, here's the thing. Let's say the Court of Appeals remands it.
Mm-hmm.
So basically, we're stuck going right back to Judge Angie, right? Or can the Court of Appeals send it to another judge?
No.
So it's basically going
they're
to
stuck with her.
Angie again.
Yeah.
Yeah. Well,
Until the remitter is filed, which would be at the conclusion of the appeal. Now, when the court remands it, they're going to set the schedule for how things go next. They could have seen it, and this is another reason why Kathleen presents at least a significant amount of information in this motion, is because the hope is they'll just grant a hearing and just bypass Judge Angie, and not let her decide whether there'll be a hearing or not.
right.
So it could be like the CD issue where they remand it and then they tell her she has 30 days to file her motion for relief. And then the state could get a chance to respond, and then she could reply again. And then the judge would decide if there was a hearing, or they should have a hearing. Or the Court of Appeals could just order a hearing directly themselves. They say, we're going to remand this for further proceedings and have a hearing on this issue. So either one could happen, but that's completely up to the discretion of the court of what they want to order.
All right.
And if they did remand it directly to an evidentiary hearing, they could also assign specific factual issues they want the court to determine. So it can be really specific, or like Tracie was saying, it could be really broad, like it was with the CD. And so she had to file a motion. The state filed a response. She filed a reply, and then remember, she issued an order and said, "Oh, the only thing that the appellate court's order said about this was a motion," and I can't remember if it was a response or not. But anyway, she said, "I didn't consider 2 of the documents, and by the way, I'm not granting a hearing, and I'm denying the motion." And so I agree. She's pointing some of this stuff out to say, if you really believe we deserve a hearing, and you should, you better be specific about it.
Right. And I think that I personally hate saying this because I don't want to sound like, if I'm wrong, I don't want everyone to freak out, but I personally don't think the court will order a hearing directly. The reason is because there was no hearing on everything else. So they would probably, why, again, in the interest of judicial economy, why order the hearing directly when it may not be warranted and delay things even longer, when they could add this issue to the appeal where they're deciding whether there should be a hearing on everything else. They might just decide obviously, if it's something that's warranted and the judge grants a hearing, that's fine. But I don't think that they'll order it directly without knowing all the facts. Because again, that would stretch it out longer than possibly necessary when they're already going to be ruling whether there should be an evidentiary hearing on everything else already. So that's just my opinion on it, but they could do it, but I just don't think they will. I don't think they have enough facts. I think there's a lot of fact finding that needs to go on. And I think that needs to be established on briefs first, and then let the judge decide if there should be a hearing on the issue. Because it would delay it several months if they were just to order a hearing, just to possibly end up in the same place. So.
All right. Sorry. So, I think, well, pretty much gone through most of it there. I think
We've gone
My
through it
question
all.
about whether it would go back to Judge Angie. I guess I do have one follow-up question on that. You're saying that obviously you're saying they could grant an evidentiary hearing themselves. Is there a scenario where they could send it back to the circuit court and, like you were saying, set up like a schedule where they make Judge Angie do certain things? Or
Yeah, they did that with they did that with the CD issue. They said that Kathleen had 30 days to file a supplemental motion, and then the state had 30 days to respond. And then I believe they gave Judge Suckwitz like 60 days to make a decision on whether there would be a hearing. So it'd probably be something similar to that.
okay, so not okay. Well, okay, so
Generally,
not what I
by
hoped for.
by statute, she can take 90 days, but I think last time they just gave her 60. They probably figured this is one issue. You don't need 3 months to decide this. So.
Or they could tell her, we want you to make findings of fact and conclusions of law after an evidentiary hearing regarding these issues.
And I said, I just don't
that's
see them
less
doing
likely.
that. Yeah. When it's on the table already that they're going to be evaluating everything for evidentiary hearing, they would probably want her to read the briefs and say, is it really necessary to have a hearing now? And if not, it's questionable. Well, then you might as well put it with all the other questionable stuff that might need a hearing, because then it can all be addressed at the same time. So that's just, like I said, they might do it. The reasoning, I could see why they wouldn't.
Right. Okay. Anything else, Travis? Anybody got questions you want to ask Tracie or Travis while they're here? Let's see if there's any here. Diagram. Oh, that's.
Linda asked,
Can
so
you guys give? Oh, sorry. Go ahead.
so all of this is basically when she gets a hearing, she will be able to put all of the stuff in with her hearing. I'd say that's true in part. What she's, that Linda assumes ultimately she is going to get a hearing. What she was asking for with this motion is to be able to go back to the circuit court and convince the circuit court that there should be an evidentiary hearing on these issues that she raised in this motion with regard to the return of the bones. And in her original motion, she specified who she wanted in her evidentiary hearing. And so I think she's hoping the appellate court, the Court of Appeals, will order an evidentiary hearing, but like Tracie indicated, they may not. They may do it exactly how they did it with regard to the CD, computer CD, and just order a briefing schedule.
Right. Okay. Mark Havy asks, can you guys give your interpretation of 968-205 and its circular nature? And he goes on to say subsection 2 seems to reflect on subsection 3.
Mark, we had this conversation in my group. He asked this exact question and I answered it. Did you not like my answer, Mark?
Okay.
Maybe he thought everybody else
or did he or did he just want to know what everybody else thought about it or ask? So I started laughing. I'm like, we had this exact conversation.
All right. I concurred with Tracie, so I don't have anything. Do you want to briefly lay it out again, or just refer people back to your group?
The question was that in 968-205-2, which establishes that it has to, they have to preserve biological evidence that is from the victim or from anybody that could reasonably, or from anything that could reasonably incriminate or exculpate another person. But at the beginning of the statute, they say except as provided in sub 5 or sub 3. Sorry, sub 3. I think that's what it is, or sub 5. One of the
sub
two.
3. You're right.
It's sub 3. Okay. Then you need to preserve it. So since it's sub 2 is referring to sub 3. It was confusing, and that's what we. So then, so Mark thought that is it possible that 3, when it comes to written notice, is referring to all evidence and not just evidence that's from the victim or it could be exculpatory. And I said, well, no, because if you look at 3, it also references 2. So there are circular references. So what they're saying in 2, when they say except as provided in sub 3, they're saying, unless you took the proper procedure under sub 3 and disposed of this the way we've set forth, then you need to preserve all of this other stuff, Okay, so you're saying that you can get rid of something that belonged to the victim if you properly dispose of it, as we said in sub 3. That's what it's saying. And I get that it's confusing, referring to a sub that is afterward first, but that's just how it works. But the language of the statute also suggests that when they're talking about written notice needs to be given, they're referring to what needs to be kept under sub 2.
Mm-hmm.
You know, so, and that's a little confusing because I know Kathleen kind of mentioned, well, they have to give written notice when they dispose of anything. I'm like, no, they have to get written notice if they dispose of anything that they were supposed to keep under sub 2.
Right.
So, so that's why it was confusing, and that's what Mark was asking. He just thought, is it possible that they meant under 3 that should come first and then 2? I'm like, no. And I said, statutes are weird. They do that all the time. There are circular references all the time.
Right. Okay.
But that's right. You know, it's back when I started first looking at the evidence preservation statute, and when that came up was September 18th, getting ready to go over her motion. And we, discovered that she had given away they'd given away the bones to the hall box, or a portion of the bones. And well, aren't they supposed to maintain this? And then your subscribers, the wrecking crew, started doing research, and they started feeding me these statutes, and I read it first. It made perfect sense to me, which scares me now, because then Allie said, hey, Travis, I don't know if you know who Tracie is, but she's got a Facebook group, basically a lawyer, and she's got a little different interpretation on this. And so I go over there, and Tracie had talked about it a little bit, and I started looking at it, and I'm like, well, yeah, you could read it that way. And, you have to read through that thing 3 or 4 times, and it's not the most artfully drafted stat. But now, because of further research that Tracie has done, and has done started the basic framework of a legislative history, she found out that, originally it just said you have to preserve biological material, period. No, there was no
qualifier. There were no qualifiers. It was just everything.
And no safe harbor to destroy it if you send notice. And so frequently, Mark, where you have a statute that starts out one way, and then the legislature adds to it later on, and they tuck stuff under. Frequently, they don't jive 100% because they weren't written at one time. They were written 4 or 5 years apart.
And sometimes it doesn't even matter, because the preservation of evidence statute was written in 2001, and sub 2 was basically all that it was. Well, then they decided when they were going to create more, they added sub 3, but then they added 2M. 2M. Why? What happened to A, B, C, D, E, F, G, H, I, K, L? How random is that? And that was created that way. So they just do weird things. And in sub 3, they actually reference sub 5, which comes later. And now I'm used to reading Wisconsin statutes, so I didn't even remember it said sub 3, because I'm so used to how they word things. But I can see why it's really confusing to people that aren't used to Wisconsin laws, because they're written really weird.
Well, hopefully we've helped clear that up for those who were wondering about 923.
I'm sorry, I wasn't terribly eloquent because I didn't have the statute in front of me at the time. I just opened it up now. So I'm sorry, my explanation at the time was a little rambly because I didn't have it in front of me. I was just doing it from memory.
All right. Okay, so I don't really see very many questions. So if you guys don't have anything else, or if you guys want to go ahead and wrap up real quick with what you want to say, and we'll cut into Stacy. We get to listen to some Stacy.
Let me start. Okay, I'll let Tracie follow up. But if your moderators last time were able to put a link to her I don't know if it was her Facebook or YouTube last time, but if you haven't checked that out,
Oh, yes,
Tracie's
please.
got a great Facebook group that deals only with legal issues, folks. It says right there in the description. She's about the legal aspects of the Stephen Avery and Brendan Gaffney case. She's been doing it for years. She's not a newcomer to this. She just great on the law, and she really has a great knack. She doesn't speak lawyer like I do. She can really put complex legal concepts into everyday language. And the comments we've been seeing since she started joining us over here is people have gotten, for the first time, some of these concepts after she came on and explained it. So Tracie, sincerely, thank you so much for taking the time to come on and help me try and explain
Thank you, both of you.
Complex stuff.
Yeah, thank you, both of you, for having me on, and Travis for always letting me like kind of bounce things off you. Whenever I find a citation, I immediately send it to him. I'm like, can you believe this? You know, so it's kind of nice to have somebody like to look at things too and say, what do you think about this? What do you think about that? So it's worked out pretty good.
Accidentally misinterpret abandon. Anyway.
Yes, we did that together. That was both of us. So thanks for letting me be on. To me, the most important thing is that I just try to make sure people have an understanding of it, even if it's not always the best news or it's not. Like I said, I'm always the one that's like kind of the Debbie Downer because I keep things real. But you know, it's easier to manage expectations when you actually understand what is being discussed and argued. So I just want people to be able to have a better understanding it, learn something from it. Maybe someday more people will learn how to read a Wisconsin law. It's not easy. That's all I want to do. So I appreciate you letting me come on and clear some things up.
Absolutely. I mean, man, it informs the conversation more. You know, it helps everybody here who doesn't understand the law to get some kind of grasp on, you know, how this works at least, or at least what to look for moving forward as we incrementally kind of creep forward. So I think it helps. You guys got the knowledge that helps to put this into perspective. So I thank you both for being here. You know, I have a lot of fun talking with you guys. So hopefully we'll be able to continue to do this whenever there's stuff to talk about, you know, whenever there's emotion or, you know, responses.
Well, just wait till she does file this appellate brief, because we'll have to be here for like 12 hours probably trying to go through that.
Yeah.
150 pages of an appellate brief or whatever. This is like 9 pages. Yeah, it's an hour and a half.
It's like what we're doing with the MPCR right now. It's like,
right.
It just keeps growing.
So there's going to be a lot more coming down the road eventually. So
yeah. So well, it'll be great to have you guys both here to help everybody understand it. And thank you guys both for being here. And let's go ahead and listen to some Stacy.
Stick around if you can, Tracie, and we'll catch you after the songs.
Okay, that's fine.
Okay.
Don't get straight, no, no. Well, I ain't getting straight. Don't get straight. I ain't getting straight. I'm sick of the suffering. Can't stand the pain. Don't get straight. Well, we know the story. All ain't the way they said. We can see plain as day. They got to Brendan's head. Totally insane. Don't get strange. Everything they got, questionable evidence gathered by many walks. Oh, it makes such sense of why they're in the game. Don't get strange. Don't get straight, no, no, no. I ain't getting straight. Don't get straight. I ain't getting straight. And that lion that that cheating, that predatory sweaty. Anything he says,
You can throw away.
he's a legal state. Don't get strange. Or may we finally find out who's to blame. Don't get strange.
Don't get strange, folks. It's good advice.
Oh, may we finally find out who's to blame. Don't get strange. Oh, Mama and Papa Avery, this one's for you. Just letting you know the world can't see what they have put you through. Not that we could ever fathom or try to imagine the depth of your pain. But the case was a sham, the trial was a scam. The DA, he's a legal stain. I said, Mama, Papa Avery, we stand with you. No matter what the state says, their lies we see through, because the blood, it was a planet, the car was a planet, Sam William Henry 582. The bones, they were planted, the bullet, yeah, planted, the key in the bedroom too. I said, Mama and Papa Avery, we send our love to you. Just letting you know we can't see what they did and continue to do. Oh, Mama and Papa Avery said this one's for you. Just letting you know we can't see what they have put you through.
All right, folks, that's it. You know the drill. If you haven't already, please hit subscribe, and we'll see you next time.